Good afternoon, and welcome to the Quarles and Brady Business Law Training Session titled H-1B, Forecast for 2020, the new H-1B Lottery Registration System and Other H-1B Trends. I'm Kim Mahan, a partner here in the Business Law Group in Chicago. As always, we have a few housekeeping items to review. For CLE credit, for our in-person guests, please fill out the sign-in sheet located at the registration table before you leave today. For our webinar guests, please email the CLE form located at the back of the PDF materials to Jennifer Michalowski, whose contact information is on the form. You can find today's PDF web materials under handouts in the Go To Webinar pop-up box on your screen. If you are listening via webinar and have a question, please type your question into the question box on the upper right side of the screen and press send. The conference host will make sure the speaker receives the message. Also, for our webinar participants, we have muted all phone lines and participants are in a listen-only mode. A survey will be emailed to you following the program. Please be aware that this presentation is being recorded. And now I'd like to introduce our speakers. Our presenters today are Maria Kallmeyer, a partner in the Immigration Group, and Emily Serschel, an associate attorney in our Immigration Group. Both Emily and Maria advise large and small businesses on all aspects of employment-related immigration law, including employment strategies, corporate immigration compliance, and visa processing for foreign national employees. Presently, our immigration team is made up of approximately 30 timekeepers dedicated to our employment-based immigration law practice. The group handles immigration matters in a variety of industries, including healthcare, professional sports, manufacturing, biomedical, pharmaceutical, and IT consulting. And now I'll turn it over to Maria.
Thank you, Kim, and thank you everyone for joining us today. We hope this can be a very exciting presentation, but also a discussion, so please feel free to ask questions. You can send questions in on the webinar, or if you're in person, feel free to raise your hand and ask a question. What we're going to do today is sort of walk through the H-1B program. So we're going to start out with some basics. What is an H-1B? How does it fit into the greater scheme of immigration law? And then we're going to talk about the new H-1B procedure for the H-1B cap, the new registration process, which I know everyone probably has a lot of questions about. And then Emily's going to focus on what happens next. So if you're lucky enough to win the lottery and actually get one of those H-1Bs for the year, then what? Then what happens? How can we get that H-1B approved? So to start, I want to go back to some basics for those of you who are newer to immigration to just kind of make sure we're all on the same page. So the way I like to think about immigration law is there are sort of three levels of immigration benefits. So a foreign national usually starts coming to the U.S. on what we call a non-immigrant visa. A non-immigrant visa is just a visa option that is categorized in the regulations by letter, and each one of those letters represents a reason that an individual can be in the United States. And it's very specific, and each one has very specific requirements that we need to follow. So today we're talking about only the H-1B category, which is just one of those many categories, and all the requirements for that. But then what typically happens for foreign nationals is they move on to applying for a green card or an immigrant visa, which allows them to stay in the U.S. permanently. They can work for any employer. They can do basically anything in the United States that a U.S. citizen can do, except for vote or commit certain crimes. And then after being a permanent resident for 3 or 5 years, depending on how that individual became a permanent resident, they would be eligible to apply for citizenship. So those are really the three levels of immigration benefits that are adjudicated within the U.S. And then there's, of course, the fourth group of people, those people who are undocumented, which typically means there isn't a visa category for them under the law, and they have still come to the United States anyway. So the H-1B program, as I mentioned, it's just one type of the non-immigrant visas. It's the most basic type of employment-based visa, and the reason for that is because There's no nationality requirement like there are for a lot of the other visa types, and there's also no requirement that the individual had worked abroad for the employer like there is for an L1, which is one of the other really common employment-based visa types. There is a requirement, though, that the individual has a minimum of a bachelor's degree in a specialized field. So, and that the job requires that degree. So that's what we call specialty occupation. So, for example, an accountant with an accounting degree would be someone who qualifies for that. And we have up there the definition of specialty occupation, and the reason why we put that on the slide is just because a lot of times we get questions on what's changing in immigration law now, what's happening with the H-1B program. This line that's bolded in the regulation is what's changing. The regulations haven't changed, but CIS is really reinterpreting what specialty occupation means and what the definition of specialty occupation is through adjudication and the way they adjudicate cases in real time. Emily's going to talk a lot more about that, but that's where it is. That's where we see it in the law. Other H-1B requirements are, of course, that when you file a petition, it has to be for a specific location and changes matter, so we have to report any changes to the government. They're also limited in time, so an individual can have an H-1B for a total of 6 years in 3-year increments unless they've started the green card process. Employers are also required to pay a certain wage. It has to be the higher of the Department of Labor's prevailing wage, which is a wage based on their own salary surveys, or the actual wage, which is just the wage that employers pay other workers in the same or similar job. So let's just for hypothetical purposes to sort of think through this whole presentation, talk about what a perfect case would be. So a perfect case in my mind might be a software developer with a computer science degree who graduated from Harvard and is going to be paid as much as anyone else graduating from Harvard that year is going to make. So if you have that person, it should be easy, right? You can get an H-1B, no problem. Well, not exactly, because there is also an H-1B cap, and it's a cap on the number of individuals who can get a new H-1B per year. So the numbers are up on the slide, but there are 65,000 new H-1Bs available per year for people who haven't had them before, and those are for anyone, bachelor's degree or master's degree. We also oftentimes refer to it as a bachelor's degree cap because that's the minimum, but really anybody can get an H-1B in that group. But there are another 20,000 H-1Bs that are set aside specifically for people who have master's degrees for a from a US-based institution. And the timeline for those new H-1Bs corresponds with the government's fiscal year. So the government's fiscal year starts on October 1st every year, and you can apply for a new H-1B 6 months before the beginning of the government's fiscal year. So in years past, if you're familiar with the program, you probably know we filed all of the H-1Bs for the year on April 1st, or within the first 5 business days of April when the government had their filing window opening. So historically what's happened is within those first 5 days, the Immigration Service has received around 200,000 petitions for the 85,000 that are available. So you can see the statistics for the last 4 years up there. Generally, it means that they receive all those petitions, then they have entered them into their system. So when I say petitions, we're filing for our perfect applicant about a ream of paper with forms and supporting documents and support letters to explain why that individual is eligible. So USCIS has been receiving those 200,000 petitions, entering them into their system, and then 30 to 40% of them, depending on whether you had a U.S. master's or not, were accepted for adjudication, and the other 60 to 70% of those cases were sent back. So for those cases that were sent back in the past, USCIS didn't receive anything. They sent it back with the filing fee as well. So that's been a big cost for USCIS to be able to accept all those H-1B petitions, enter them into their system, run the H-1B lottery, and then send them all back to us. So that's sort of the basis of why USCIS wanted to change the lottery registration process and create this registration process. It's been an operational thing that's been in the works at USCIS for many years. I don't think it's necessarily political. So before I talk about the new registration process, I also want to mention who's not subject to the cap, because that's a big thing to know who this does not apply to. So there are two sort of buckets of reasons why a person would not be subject to the H-1B cap. The first bucket is for people who are individually exempt from the cap. So anyone who's been counted against the cap before will not be counted again. So any of your current employees working for a for-profit company who got an H-1B in the years past do not have to go through this registration process again. It's a one-time only thing, even under this new process. Also, H-1B beneficiaries candidates who you might want to employ who are coming from a different employer but have been counted against the cap in the past, they do not need to go again. Each individual is only counted once. The other group of individuals are Conrad 30 J1 waiver recipients. So those are physicians who have agreed to work in underserved areas and received a Conrad 30J waiver are not, they are exempt from the H-1B cap. And then there are also a group of employers who are exempt. So for the employers that are exempt, everybody who they apply for an H-1B, all of their employees are exempt. So those are institutions of higher education, research institutions, and then nonprofit organizations that are affiliated with institutions of higher education are also exempt from the H-1B cap. Okay, so now the fun begins with the new regulation. The new regulation was published on January 31st, 2019. And yes, I said that correct. It came out last year before the H-1B cap last year. But USCIS took this year to prepare and to develop the technology for the registration system. So there were two main things that the new regulation changed, and these are really procedural things that they changed. The first thing that they changed was the order of the lottery, and this change actually did happen last year. So the way they run the lottery now is that first they run the general lottery, so all applicants who apply are put in the same initial lottery, and then they run the lottery, and then of those people who were not selected in the first lottery, if they happen to have a U.S. master's degree, then they get entered into the second lottery for the other additional 20,000 H-1Bs for the year. And then the second thing that this new regulation did was it created a brand new procedural registration process for H-1Bs. So we're calling it the registration process because it is now a two-step procedural process, and you first have to register on USCIS's website in order to be eligible to file an H-1B petition on April 1st or after. So the registration process is available on, well, it is sort of available now. It will be available by March 1st on USCIS's portal. And they are charging a $10 fee for this initial registration process. So here is the new timeline for the H-1B cap and the registration process. Between now and March 1st is when you should be thinking about H-1B employees who you need to start by October 1st, 2020. And you should be gathering those lists, talking with your immigration attorneys about it, thinking about strategies and things like that. On March 1st, USCIS is going to open up the registration process. So from March 1st to March 20th, employers can submit registrations for employees who they want to apply for a lottery, an H-1B for in the lottery. It doesn't matter if you enter your registration on March 1st or March 15th or March 19th. There's no first in, first out or anything like that with the registration. It's after March 20th. USCIS is going to take everyone who registered in the initial process and run it through the lottery. So it's going to be an electronic lottery that USCIS has committed to finalizing by March 31st. And then after the lottery is run, USCIS is going to announce a 90-day window in which people can file the H-1B petitions. We expect that 90-day window to open around April 1st, but USCIS has not yet published exactly when it's going to open and when they're going to allow employers to file. They have indicated that it will be 90 days or that it could be longer, but those details still have not been, the rest of the details still have not been published. So for registration, if you want to submit one, what do you need to have? What do you need to put in the registration? So we know you have to pay $10 and you have to put in these items that are up on the slide, these 9 points. And when I say you, I mean employers need to put in this information and register their employees. So employers, of course, need to put in the legal name of the employer, the petitioner, their FEIN number, the primary U.S. office for the employer. That's not the work site that they need to put in, but the actual primary U.S. office for the employer. We also need to put in the legal name, title, and information on the authorized signatory. We don't yet have any guidance on what happens if that authorized signatory changes between the point of registration and the petition. Does it have to be the same person on the petition as was signed up in the registration program? But to the extent possible, our advice on that now is try to make that consistent and decide who's going to sign now and not have to change it later for the petition. From the beneficiary, we need to have the legal name, their gender. Is the beneficiary eligible for the U.S. Master's cap is one of the questions, because that's a separate cap, of course, and they will be running it separately. There is an open question as to when does the beneficiary have to be eligible for the U.S. Master's cap? Does they have to be eligible at the point of registration on March 1st or March 2nd, or do they have to be eligible at the time of filing the H-1B petition in April? We do know that generally individuals have to be eligible at the time of filing in April, not at the time of registration, but this particular question is still open, and we've asked it of USCIS and asked for additional guidance on it. And the reason is because the language on the actual question in the electronic form says, is this person currently eligible for the U.S. Master's cap? So we're looking for additional guidance from USCIS on that. But I think for now, we can assume that the eligibility would be at the time of filing. And then, of course, the beneficiary's date and country of birth and the passport number. So you have these 9 data points, and you're all ready to go on March 1st. Is that it? What do you think, Emily? You think we should just go with that? Of course not. Of course, we're lawyers, so we think about the risk and everything else that could happen, and so we've been thinking about what else should we be worried about, how else should we be preparing. So here are a few additional things we want to consider. First of all, we want to talk about how much work to do ahead of time before the lottery versus not. And I think that's really going to be a cost-benefit analysis that's going to be employer-specific based on how many people you have, who your foreign national population is, how much work you think it might be to get those petitions ready during the 90-day period. And of course, we're happy to talk to people about that on an individual basis and what we think makes the most sense for your company. But for everybody, you should be thinking about F1 student issues. So if you have employees who are currently working for you who are in F1 status and they're working on their optional practical training or OPT, we have to monitor the expirations of those OPTs because there is a provision in the law that we call cap gap, and that allows beneficiaries to continue working in the summer, essentially. So a lot of those optional practical training employment authorization cards are valid essentially spring to spring, depending on when people graduate in June, and then they get 1 year until the next spring. So we want to look at those expiration dates, and the cap gap will then extend them until October 1st if the H-1B was filed before the expiration date on that employment authorization card. So up front, I think we want to know, does somebody have an employment authorization card that expires on April 3rd or April 20th or May 1st, because we want to make sure that, of course, to prioritize those cases and file those H-1Bs, the full petition H-1B in time for that employment authorization card to expire. So essentially well before the 90-day window ends. The other thing we want to talk about is qualifying degree. That really goes to basic eligibility for an H-1B. Is this a job that's eligible for an H-1B? Does the individual have a degree that qualifies? Whether or not you want to get into that level of detail is, again, going to be an employer-specific question, but I think a lot of employers will think it doesn't make sense to spend the resources on this registration process, even if it's going to be for a candidate who's ultimately not going to qualify. There are some employer attestations as well that are on the registration process, and that is that the employer has to attest that there's a bona fide job offer, of course, open for any individuals who they put into the registration process. The way USCIS has said they're going to monitor this is they're going to look for employers who have a pattern or practice of submitting H-1B registrations for people who they don't ultimately file an H-1B petition for. So that's just to say, to be aware of, we know business circumstances change, and there probably will be from time to time some people that employers put into the registration process who then don't end up needing to file a full H-1B petition. But to the extent possible, you should plan for that, know who you want to put into the registration system ahead of time on March 1st and not be making changes later. And then prioritization of filing. So it's sort of this open question, should we prepare everything now and kind of go through a similar process that we have in years past where we've prepared a full petition and had it ready to go on April 1st? Or should we wait and prepare everything later after we find out who's selected in the lottery? And again, I think that's going to be an employer-specific question, but I think there's sort of 3 schools of thought on how to do it. One is to prepare the entire petition now. So some employers are thinking that they want to have all their employees ready to go as soon as that 90-day window opens. And so those employers are deciding to prepare the entire petition now and have it ready to go and file right away when the 90 days opens. Other employers are taking sort of the opposite approach of only doing the registration process. We're putting in these 9 data points and that's it. Everything else we're going to worry about later. And we're going to take that full 90 days, prepare those petitions only for those selected, and make sure that we have a good petition in at that time. And then the sort of third school of thought is to do some basic preparation now to make sure that our foreign nationals are eligible, to make sure we have a list of prioritization for our employees. So, you know, we know who has an F1 OPT issue that we need to monitor, and who has another legal issue that we need to be aware of, so that we can prioritize and decide who to file in what order within that 90-day window. I think that third approach is probably the one that's going to be most common and best for most employers, to make sure the legal requirements are met and you're not entering people into the lottery who aren't going to be eligible anyway, but not spending a ton of resources either on preparing a full petition that is ultimately not going to be used. So to close the registration process, part of this process, I do want to acknowledge that there are still a lot of unanswered questions. We're monitoring those unanswered questions and working with the American Immigration Lawyers Association to get answers as soon as possible. USCIS has not announced anything about premium processing yet. There are some questions about USCIS's technology and how well that's going to go. USCIS has been working through what they call a transformation process since 2005, where they've been trying to make all their benefits electronic. And I just have a little quote. It's from the 2016 Department of Homeland Security Inspector General report. It says, past automation attempts have been hampered by ineffective planning, multiple changes in direction, and inconsistent stakeholder involvement. So we don't expect this registration process to be much better than that, unfortunately, but we're on top of knowing what there is to know about it, and we're committed to working through it with our clients. So to end on an optimistic point, let's assume our perfect foreign national that I talked about before wins the lottery, wins the registration process, and is ready to file the H-1B petition and live happily ever after. Emily is going to talk about what that means and what happens next, and then how that employers can actually get their H-1B petitions approved. I also see some questions here.
Before we jump in, just to clarify. So first, Maria, do the new petitions that you're talking about, the new H-1Bs, does that include renewals for second and third year terms? So if we can just clarify what a new H-1B petition is.
Right. No, the new petitions do not include renewals. So if anyone who has had an H-1B petition before, that would be a renewal or an extension, they do not need to be placed in the lottery again. They do not need to go through this registration process.
And I think this is a great question, and certainly one that is causing a lot of us to just be a little nervous about the lottery. So any changes to the lottery that will improve access for smaller employers or startups versus large employers who might file a large amount of petitions?
Yeah, that's a great question and a concern that we all have. Unfortunately, what USCIS has said about that is that they've pointed out that they're going to investigate employers for fraud, as I said, if they put in a lot of petitions or a lot of registrations that they don't end up filing petitions for. But of course, the concern is there are some companies that are very large and have the ability to put in a lot of beneficiaries into the system, and then ultimately just file for those beneficiaries that are selected. So I think that is a concern for smaller employers. Generally, I think it's also a technology concern. USCIS has spent this year testing the system for around 200,000 H-1B petitions. So what happens if there's actually 500,000 this year? Is that going to crash the system? Possibly. The answer. Yeah. Is there all the questions?
I just want to speak to that one. We'll talk about that one a little bit more.
All right, go ahead, Emily.
All right, great. Thanks, Maria. So up to this point, we've been talking about the procedural shifts that we are going to see over the next couple months and throughout the year. But I just want to shift and talk about what can we substantively expect to see in the year 2020 when USCIS, U.S. Citizenship and Immigration Services, is actually adjudicating these H-1B petitions. So we've learned a lot in 2018, 2019, sort of the trends, how the government is adjudicating these petitions. And we unfortunately do anticipate that we're going to continue to see some of these, this heightened scrutiny, certainly across the board. So what do we know to be true? We know for a fact that the substantive regulations, the substantive H-1B regulations, how we actually qualify for an H-1B petition, those regulations have not changed. As Maria discussed, there's been procedural changes to how the lottery will be conducted, but the substance of how we actually qualify for an H-1B petition has remained constant. However, we also know that the way the government has been applying and interpreting that same regulation has certainly changed. So we've seen a dramatic increase in the level of scrutiny, which has resulted in more requests for additional evidence from the government, as well as ultimate denials. We also know that the legal standard of review is the preponderance of the evidence. So going back to our law school days, this is more likely than not that something is true. But we've also seen over the past couple of years, and we anticipate in 2020, that we're going to continue to see a heightened level of scrutiny. So going almost to an abuse of discretion, using a higher level of legal standard when reviewing these petitions. And we've seen people push back in litigation and appeals, arguing that there's been this abuse of discretion. So let's take a deeper dive into the actual statistics, what we've seen. So this first slide shows, it's pulled from the 2018 USCIS Statistical Annual Report. So disclaimer, it does not include fiscal year 2019 in this data, but I think it still really demonstrates the trends. So drawing your attention specifically to this approval rate, this bottom section, looking at the H-1B beneficiaries. And another note about this data, first of all, this is looking at all H-1B petitions filed. So it's not just our CAP cases. This is also looking at H-1B renewals, H-1B change of employers. And this data is certainly average data. So many of us who work in immigration deal with some companies that receive higher denial rates. Certainly companies that are based in India often are the victim of higher denial rates, how the government is looking at those. So this data is certainly average data. So it's not out of the ordinary if your company does see higher denial rates. But you can see here that between fiscal year 2014 and 2017, we were happily treading with a 93 to 96% approval rating for our H-1B petitions. But then all of a sudden, fiscal year 2018, we saw a dip in approvals to a much lower 85%. Looking one level deeper, this graph shows the denial rate for our initial employment H-1B petitions. So these are going to be the petitions that Maria was talking about. Our H-1B CAP cases, those who've never held H-1B status before. This graph, again, is very telling. You can see 2017, we're looking under the 15% mark. All of a sudden, 2018, 2019, we're close to 25% denial rates for those initial H-1B petitions. Again, keeping in mind, the substance of those regulations has not changed. We're still dealing with the same black letter of the law in those regulations, but these charts are really illustrative of how the government was able to, or is able to apply and interpret those regulations at in a different manner to really, I don't want to say manipulate, sort of modify the H-1B program without actually going through the formal rulemaking process. This graph, I think, is actually the most telling and the most staggering data. So this specific chart is looking specifically at H-1B petitions with continuing employment. So this chart is looking at H-1B petitions that have been approved in the past, and now they're up for renewal. So by definition, the government has already looked at these H-1B petitions and found them to be approvable under the regulations. But here we are at the renewal asking for approval for continuing employment, and you see the denials have dramatically increased here as well. So again, this is just very telling that even though the regulations haven't changed, the government is able to use the H-1B adjudication process as a tool to really impact how H-1B employers can actually utilize that program. So what's going on? How are they possibly doing this? Again, regulations are the same. What we've seen over the past couple of years, and again, we anticipate in 2020, is that the government will continue to hone in on this specific item, which is the specialty occupation aspect of the H-1B petition. This is actually the most frequent issue that is brought up in requests for evidence. About 60% of RFEs will have this element of specialty occupation. So as Maria explained, and we put the regulation up here again, basically in order to qualify as a specialty occupation, we need to show that the position normally requires a bachelor's degree in a specific field of study. So when the government has questions about this, they're asking how can it truly require a specific field of study in order to qualify? So the regulations, they start with that definition, and then they go on to further itemize 4 different ways that we can show how something qualifies as a specialty occupation. So if we can show one of these 4 prongs, then we're golden, case is approved. So the first way that we can show that something would qualify as an H-1B petition is to show that a bachelor's degree or its equivalent in a specific field is normally the minimum requirement for entry into that particular position. So now this begs the question, who or what is the authority on what is a normal minimum requirement? And so the government, USCIS, defers to the Department of Labor through the Bureau of Labor Statistics, who's published this Occupational Outlook Handbook. And essentially, the Occupational Outlook Handbook is a resource for those individuals looking for career changes. So it's a resource for students looking for guidance. How do I get into this engineering role? There's actually a disclaimer that says it's not meant for legal purposes. However, this is the authority that USCIS really leans into when determining what is normally minimally required for this position. So the Occupational Outlook Handbook has classified these standard occupational classifications, or SOC codes. So basically there's hundreds of these standard occupational classifications where we need to try to organize or classify the roles that we're trying to sponsor people for through an H-1B into these more generalized classifications. So you can imagine sometimes that gets difficult when we have a role that may straddle a few different occupation classifications, but it's our job in connection with the employer to actually select which standard occupational classification the H-1B position best falls under. So I've included here an excerpt from the labor condition application, which is a pre-filing requirement that we have to first file with the Department of Labor before we can file an H-1B petition. And you can see here under number 2, we have to actually select the SOC that best fits this position. So we sort of are locking ourselves into this code selection when we initially file the petition. So then when the government goes to actually adjudicate this petition, they'll look at this data and they will then reference the Occupational Outlook Handbook to determine, does this SOC or this classification generally require a specific field of study in order to enter that field? So taking a look at some samples from the Occupational Outlook Handbook itself, sometimes it's a lot easier. So for example, from the software developer, here you can see, maybe you can't quite see, the education, it says software developers usually have a bachelor's degree, typically in computer science, software engineering, or a related field. So that's pretty straightforward, IT-related fields, IT position. This one generally does not give us too many issues with USCIS, but then we have some of our other occupational classifications that aren't as pretty and tied as nicely. So for example, looking at our market research analyst, the education here says market research analysts typically need a bachelor's degree in market research or a related field. Many have degrees in fields such as statistics, math, or computer science. Others have backgrounds in business, the social sciences, or communication. So you can see here, this resource that the government uses has provided a plethora of possible fields of study that somebody could go into or get a degree in order to be qualified. So using the analysis, looking at this first prong, the government would look at this and say, this position can't possibly be a specialty occupation because it doesn't satisfy that there's normally a specific field of study to qualify for the position. So effectively, by this more narrowly tailored definition, the government has eliminated some of the occupational classifications that we've historically used. Several years ago, we would use this all the time for H-1B petitions, but over the past several years, the government's pushed back. They've said, no, this is just not a specialty occupation classification because it's just not specific. The requirements aren't specific enough. So you can see if your hands are tied and you have to select a classification, that doesn't have a beautifully specific field of study to show how you qualify, it's going to be an uphill battle right out of the gates. The government's going to look at this prong and say, nope, not this one. So you have to look elsewhere to see how you could potentially show the position's qualified. So fortunately, there are 3 other ones. So we can lean on these as well if we don't knock that first one out of the park. So the second way we can show that something is a specialty occupation is by showing that the degree requirement is common to the industry in parallel positions among similar organizations. This one is tricky because I would say if the government really wants to deny your petition, they will find ways to poke holes at this evidence because it is so specific with the parallel positions among similar organizations. So generally the way to show evidence to support this is to show, for example, competitor ads. So we can go online, see what another law firm, what their hiring requirements are for this position. However, the government's come back and said, if the roles aren't similar, so are both of the positions entry level or managerial, they love to pick apart whether it's truly a similar organization. So is it the same number of employees at both companies? Is it the same type of industry? So we really need to be careful when providing evidence to support this because the government can really disregard this evidence if they truly want to. Another good form of evidence here is to provide industry letters. So if you have colleagues within the same industry who can attest that, yes, this is a normal minimum requirement, and they can sign off on that, that's some great independent evidence to corroborate as well. The third way to show that something is a specialty occupation is by showing that the employer normally requires a degree or its equivalent. So this is where we want to be having discussions with the employer to talk about their hiring history. So we want to look at similarly situated employees. We want to look at the other members of the team that the beneficiary sits on, and then look at the qualifications of those team members. So look at their resumes, diplomas, pay stubs. Does the employer truly have a history of always requiring the specific field of study to show that somebody, to hire for that position? If we can provide screenshots of previous postings for the position, that is great evidence as well to just show that history of the hiring practice. The final prong to show that somebody is qualified for an H-1B or for that a position qualifies is to show that the nature of the specific duties are so specialized and complex that a bachelor's degree is required. So this is an area where we've really beefed up our initial case preparation. Long gone are the days where we could just submit general HR job descriptions. The government wants to see very detailed job descriptions. They want to know what is this beneficiary going to do every day, the percentage of time that they're going to spend on these duties. And we found that they also really want us to connect the dots to show how are these job duties related to the overall business goals or the business model. So we especially have run into issues in the past where, for example, with a tech company who has a software developer, very clear why this company needs a software developer. However, we get pushback in different industries such as healthcare or financial institutions where the government can't quite wrap its mind around why you would possibly need a software developer in that industry. So to really show why does this hospital need to have a developer on their team? What are they going to be doing? How is that supporting the company's efforts? So really just helping the government connect the dots between why this hire needs to happen. So those are the 4 prongs to the specialty occupation piece. Again, as I mentioned, this is the most frequently issued RFE issue, and you can see why. You can see that there's a lot of discretion and subjective interpretation when we're looking at these different prongs. So it is a great tool if the government is trying to modify the H-1B program and who can actually qualify, because there is a lot of room for discretion and interpretation. But that's certainly not the only reason that we receive requests for evidence. I put out a few more issues that we do see come up very often with our requests for evidence. And so I just wanted to highlight those before we close. So the first one is maintenance of H-1B status. In order to port H-1B employment to a different employer or to renew your H-1B status, we need to show that somebody is maintaining their H-1B status at the time of filing. So the government, again, has really tightened its scrutiny on this. They want to see pay stubs up till the moment that you file that petition. They want to see that you're still employed. So that's something that we can very easily combat during our initial filings. This next issue, the employee's qualifications. This is one where we have received tons of requests for evidence over the past year, year and a half. This is sort of goes along with the specialty occupation. As we talked about, the government's really narrowly applying its definition of what is a specific field and also what is a related field. So in the past, several years ago, we would be able to argue that, or just show that somebody with, for example, a mechanical engineering degree could qualify as a software developer. So the field of what a related field of study was much broader. If somebody had a math degree, statistics, again, we could still qualify them as that software developer. However, over the past year or two, the government has much narrowly applied what is a related field. So our broader engineering degrees no longer fit into what is defined as a related field. And so we see that on the flip side here with employees' qualifications as well. So we have often had to try to get degree equivalencies. So showing how somebody's education coupled with their experience or expertise in the field, how that combined can show that somebody has the equivalent to a US bachelor's degree in that specific field. So this has also effectively allowed USCIS to really narrow the individuals who actually qualify for these positions. And it's also caused a lot of frustration, as you can imagine, with a beneficiary who, again, 3 years ago qualified with a mechanical engineering degree, but all of a sudden we're asking them to provide more and more evidence to show that they're qualified. You can see how everybody's frustrated on all levels. The government really likes to see employer-employee relationship evidence. So this often comes into play when we have remote employees working from home. They want to make sure that the employer has the control, is actually defining the work, has the ability and authority to hire and fire that individual. So often they want to see employment contracts. They want to see evidence that the employee is getting benefits from the company. So that's some additional evidence we can show there. In terms of off-site employment, so whenever there's a contractor working at a third-party client site, that's going to trigger all sorts of additional evidentiary requests. So it's sort of its own beast. We have to provide statements of work, client letters. Again, the government wants to see that there's control, that the employer has the ability to control that contractor's third-party work. And it's also important to think about it from the flip side. So a lot of companies that we work with actually have contractors placed at their client or at their own site. And so they're being asked to provide client letters. They're being asked to provide these contracts and statements of work. And so some advice there, we just recommend that there's consistency across the board. Make sure what you're signing says what the statement of work says. Don't just blindly sign something that another immigration attorney sent your way, because we do want that evidence to be consistent. It's really helpful if you designate one person at the company to be in charge of all of those client letters and statements of work, just so, again, there can be some sort of consistency there. And then finally, if there are multiple work locations, so for example, a physician who works at multiple different clinics, the government wants to see itineraries. They want a breakdown of when they'll be at what location, what are they going to be doing there, percentage of time. So we do need to provide that as well. So those are, I think that's, yes. So those are the RFE trends that we've seen in 2018, 2019, and we do anticipate that we will also see those in 2020. Some other things that we anticipate will happen in 2020 is an increase in litigation, or continuing of this increase. We've seen an uptick in litigation both at the federal level as well as appealing just through the administrative level as well. So we anticipate that employers will just continue to be fed up with the treatment, the abuse of discretion, that they're going to want to raise this to the next level. So we anticipate that there'll be some additional movement there at the litigation level. We can pretty much bank that there's still going to be an increase in the level of scrutiny that the government's evaluating these petitions. Again, same higher levels of RFEs, denials. Unfortunately, we see those in our future as well. One thing to just keep your eyes open for, the government's hinted that it will be looking to actually go through the official rulemaking process to actually codify this policy they've sort of created just by how they've been adjudicating petitions. So we anticipate that there could actually be a regulation that solidifies this higher level of scrutiny that we're seeing.
Thank you, Emily. I just have a few things to add on the litigation front. The reason we're seeing an increase in litigation is because the recourse of, you've seen the denial rates, there's a much higher denial rates. And unfortunately, the recourse at USCIS isn't great. So if you get a denial, you can file an appeal or a motion to reopen and reconsider, and you're essentially sending that petition back to the same agency to be adjudicated again and asking for a different result. So the statistics on that are poor, and it's not always a wonderful option. But what happens in litigation is essentially you're suing the government in federal court, and then the petition or the litigation ends up on the desk of the lawyers at USCIS, who tend to have a little bit of a different opinion on what's reasonable and what's not, and oftentimes they send it back to the adjudicator and tell them to approve the case, and then very shortly after you started litigation, you get an approval notice in the mail. So that's not to say that's always going to happen, and it certainly should be a case-by-case discussion with your immigration lawyer, but that's really why employers are deciding to litigate more than we ever have before. Another thing I wanted to do is just take a quick look back at some of the statistics. And if you're looking at these statistics and I'm your lawyer, of course, you're thinking, wow, Maria's awesome because I have a 99% approval rate and it's way above the average. But I just wanted to point out that this is an average, and there are things that USCIS is targeting, and they're very open about that, what they're targeting, what they're considering a problem. So there are certain employers, particularly those employers who are based in India, that are seeing a much higher denial rate than other employers. I think that's a result of the Buy American, Hire American executive order that came out, and the administration specifically saying that they want to have more Americans and support more American companies and not support companies that are not necessarily based in the United States. So I also have one other question here that came through. Has there been any movement to raise the education level to qualify? I think that's kind of what Emily was going through in her information about the RFEs and denials. The answer is, from a regulatory standpoint, no, there hasn't been any movement, but from an adjudication standpoint, certainly they're not raising the level per se, and whether it's a master's degree or a bachelor's degree, but they are raising the specifics. So where you used to be able to qualify before with maybe a mechanical engineering degree for a software engineering job, now that doesn't work anymore. You have to have a computer science degree or computer engineering degree to qualify for a computer engineering job. So they've really narrowed the education options and sort of raised the level that way. Is there another question?
Yeah. So the question is, so rejected petitions from larger employers that have displaced smaller employers not getting the opportunity through the lottery, are there any remediation?
I think that's similar to the question that we had before about the lottery, and unfortunately, no, not for this year. There's no way for the registration process to favor smaller employers or to do anything about smaller employers getting squeezed out. So it's just everybody going into the same lottery and then coming out on the other end, with the exception of individuals who have a U.S. master's degree will certainly have priority for those 20,000 H-1Bs. A question?
Yeah, I have a question. So if it, like, let's say there's 5,000 or so cases that are accepted in registration, but then people don't actually apply for whatever reason, is there any discussion of, like, are those slots just lost, or could there be potentially another lottery down the line if a lot of slots aren't used? Or?
Yeah, so that's a great question. The question is, in case it wasn't heard on the webinar, if there are, let's say, for example, 5,000 H-1Bs that are accepted in the registration process and those individuals don't actually apply or use those H-1Bs, what happens? USCIS has indicated that they're going to create a wait list. So there is going to be a wait list for individuals who were not officially accepted in the registration process but are on the wait list, much like a wait list for college or anything else. So if enough petitions aren't filed, I presume during that 90-day window, then they'll open up the wait list and allow additional people to apply, although they have not yet published exactly what the procedure for that's going to be.
And they have said if they don't receive enough petitions to fill the lottery, they'll maybe have another registration period, but.
Yeah, let's see about that. Yeah.
All right. Are there any questions from the other offices?
Can you hear Milwaukee?
I can.
Yes.
Okay, I just have a similar question to the one that was just posed about people who registered and then did not apply in the 90-day window. What about cases that are ultimately denied, which could be as high as 25% of the petitions that were filed? That's a lot of unused numbers in the cap that are being wasted, right?
Mm-hmm.
Right, and I think we've all had that concern even now, what's happening to all those numbers, and I don't know if you have more information on this, Emily. Oh, just to repeat the question for the webinar in case you didn't hear it. The question was, what if there are a lot of H-1B petitions that get denied? Are those going to get sent back into the lottery because there's as we saw, a 25% denial rate? Is there any recourse for those going back and more petitions being used? And I think the answer is that we don't know exactly what's going to happen for that, but we hope that the government will use that wait list for the same benefit. And our hope is this was an operational change at USCIS because they were overwhelmed by the significant number of petitions that were filed. Our hope is that they'll use that to their benefit. It frankly should be a lot easier for them. They're going to get a lot less petitions and they're going to have a lot less work to do. Hopefully they'll use that extra time they have to the benefit of us. We'll see. Everyone in Chicago's laughing. Okay, any other questions in the other offices? Oh, one here.
So when they run the lottery from March 21st,
31st, are they going to, do they say how they're actually going to notify you if you've been selected, like a receipt or like an email, or how are they going to notify us when we have cases received in the registration or accepted?
So the question is, after they run the lottery, after USCIS runs the registration lottery, how are applicants going to be notified? And of course, they have not put out extensive information on that either, but our assumption is, and what the American Immigration Lawyers Association is assuming, is that it's going to be through the same portal, that you would be able to log back into USCIS portal where you submitted the registration in the first place and see there whether or not you've been selected or whether your employees have been selected. Because I should emphasize that this is an employer-based. Employers are registering for individual employees. Individual employees are not registering for themselves. Any other questions?
a follow-up to what you just said. If the employer is submitting or registering individuals, though, and it's the individuals that are chosen yes or no in the lottery, or is it the employer put in 20 candidates and they got 3 slots and then they can pick which 3 people to put in there, or is it each individual is a yes, no?
Great question. So the question is, since employers are the ones putting in the beneficiaries, is it the employer gets selected for 3 slots and the employer can pick who the 3 people are, or is it that the beneficiaries are individually selected? And the answer is the beneficiaries are individually selected. So you as an employer, unfortunately, cannot prioritize who you would want to be selected in the lottery. You put in your people and then you get who you get. Okay, any other questions? Okay, well, thank you everyone for joining